Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. Starting with an update from the Supreme Court. A bench of Justices B.V. Nagaratna and Ujjal Bhuyan has been hearing the batch of petitions challenging the decision of Gujarat government to grant remission to the 11 convicts who had been sentenced to life imprisonment for multiple murders and the gang rape during the 2002 communal riots in Gujarat. In a new update, senior advocate V. Chidambaresh, appearing for the released convicts, has told the Supreme Court that a remission order can be challenged only in a High Court and not in the Supreme Court, pointing out that Article 226 of the Constitution, which conferred on High Courts the power to issue writs, was wider than Article 32. When Justice Nagaratna pointed out that one of the convicts had filed a petition under Article 32, Advocate Chidambaresh replied that it was before the remission was granted. Once there is an order of remission, judicial review is permissible only under Article 226. The respondents have concluded their oral arguments in the matter. The matter has now been posted to 4th October when the petitioners are anticipated to present their counter arguments. Advocate Shobha Gupta represents Bilkis Bano, who is one of the main petitioners among a number of petitions filed in the public interest challenging the Gujarat government's decision. Advocate Shobha had earlier argued that the punishment imposed on Bilkis's rapists ought to be proportional to the nature and seriousness of the crime they had committed, which included 14 murders and 3 gang rapes. Stay tuned with us for further updates in this case. Coming to an update on the long-standing dispute between the states of Karnataka and Tamil Nadu regarding Cauvery river water. The Kaveri Water Management Authority, that is CWMA, had directed the state of Karnataka to release 5,000 caustics of water at Biligundlu for 15 days. This order pertains to the period of 13th to 27th September. The Supreme Court today refused to interfere with this order. A bench of Justice B.R. Gavai, Justice P.S. Narasimha and Justice Prashant Kumar Mishra has observed that the CWMA consists of various experts in the field of water resource management and agriculture. It has taken into consideration the shortfall of water this year and various other factors, including the increasing distress condition in the Kaveri basin in the last 15 days. The court also observed that the situation is being monitored by the appropriate authorities every 15 days. You can visit our website for more information on this matter. And now an update on the 2018 caste-based violence that broke out at Bhima Koregaon near Pune. One of the accused, Mahesh Raut, was granted bail by the Bombay High Court today. Raut, a tribal rights activist, has been behind bars since his arrest in June 2018 over alleged links with Maoists. Senior advocate Mihir Desai, representing Raut, had argued that he was not a member of the banned CPI Maoist outfit as claimed by NIA, but in fact was a recipient of the Prime Minister's Fellowship. He is an activist working for Adivasis in Gadchiroli. On the other hand, Additional Solicitor General Devang Vyas, appearing for NIA, claimed there was evidence to show that the CPI Maoist had given Raut 5 lakh rupees along with other co-accused arrested in the case. That there was a larger conspiracy to wage war against the country and his bail was rightly rejected by the trial court. But a division bench comprising Justices A.S. Gadkari and Sharmila Deshmukh was of the view that several UAPA provisions under which Raut was charged were prima facie inapplicable and granted him the bail. This makes him the 6th person to get bail in this case. However, the High Court stayed the order granting bail for 1 week at the request of the NIA, which sought for a stay of 2 weeks. For your information, let me tell you that 16 people have been charge sheeted in this case as accused, but the trial is yet to begin. Of them, 8 are still in prison and Father Stan Swami has passed away. In another update, the Supreme Court has expressed shock at an impugned judgment of the Jharkhand High Court where the maintenance amount of 5,000 rupees awarded by the trial court was reduced to 1,000 rupees per month by the High Court. In this case, the husband had filed a criminal revision against the order of family court. He had argued that the ex parte order granting maintenance of 5,000 rupees per month to the wife was passed without hearing him, that he was a poor priest in a village temple and earned his livelihood by part-time tuition. The High Court, relying on precedents, had held that the court must consider the party's status and the spouse's capacity to pay for her or his support, and accordingly reduced maintenance to 1,000 rupees per month. But the Supreme Court has said that no justification for reducing the amount to such an extremely low limit can be found. Thus, the bench of Justices Vikram Nath and Asanuddin Amanullah set aside the impugned order, restored trial court's order awarding rupees 5,000 per month as maintenance under Section 125 of Criminal Procedure Code. A petition was filed before the Supreme Court by G. Niranjan, Senior Vice President, Telangana Pradesh Committee, pointing out issues with Form 6 and Form 6B of the Election Commission of India forms for registration in e-roll. Form 6 is the application form for new voters and Form 6B is letter of information of Aadhaar number for the purpose of electoral roll authentication. The Registration of Electors Amendment Rules 2022 was notified by the central government in June last year to provide for linking Aadhaar number with election ID cards. Form 6B is the application form by which a voter can inform the Aadhaar number for the purpose of electoral roll authentication. In this regard, the Election Commission of India has given an undertaking to the Supreme Court that it will issue appropriate clarificatory changes in Forms 6 and 6B. The bench, comprising CJI Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra, was informed that the submission of the Aadhaar number was not mandatory under Registration of Electors Amendment Rules 2022. And that the Election Commission was looking into issuing appropriate clarificatory changes in the forms introduced for that purpose. Based on the undertaking made by the ECI, the court disposed of the writ petition. Rehabilitation and reformation of inmates are critical aspects of any criminal justice system. It is essential to help individuals who have been imprisoned to reintegrate them into society as law-abiding and productive citizens. This approach focuses on addressing the underlying causes of criminal behavior and providing opportunities for personal growth and positive change. In an important update, the Supreme Court today ordered release of a convict who had spent nearly 26 years in prison, asserting that the denial of premature release violated fundamental rights protected under Article 14 and Article 21 of the Constitution. The court emphasized the need to consider the rehabilitation and reformation of inmates who may have drastically transformed during their time behind bars. The bench was considering a writ petition filed under Article 32 of the Constitution by a prisoner named Joseph, currently aged 65 years, who had been lodged in a prison in Kerala since 1998 after being convicted for the murder and robbery of a woman. The bench of Justices S. Ravindra Bhatt and Dipankar Datta has observed that nothing can be achieved by continuing to punish a person who recognizes the wrongness of what they've done, no longer identifies with it, and bears little resemblance to the person they were years earlier. Accordingly, the court allowed the petition and disposed of the pending applications. You are well aware of the Hapur incident of the tussle between advocates and the police. The lawyers had been protesting an alleged police lathi charge on advocates in the Hapur district last month, and they have been demanding action against the erring police officials as well as seeking enforcement of an advocate's protection law. The Uttar Pradesh government has now constituted a 3-member committee to consider various aspects concerning the Advocate Protection Bill and to give its recommendations to the State Law Commission. The committee, formed under the chairmanship of Principal Secretary Law, will also consist of the Additional Director General Prosecution and another member who will be named by the Uttar Pradesh Bar Council. Let me remind you here, earlier this year, Rajasthan became the first state in the country to enact a law granting protection to advocates from assault and grievous hurt. There have been ongoing discussions and demands from various legal bodies and advocacy groups across the country for enactment of legislation to protect the rights and safety of lawyers. These demands typically focus on ensuring that lawyers can perform their duties without fear of threats, attacks, or harassment. You must have seen the recent viral video where a couple who had employed a 10-year-old girl to take care of their 4-year-old minor son were manhandled and beaten up by a mob outside their house after the injury marks on the girl's arms and under her eyes were seen by the local residents. Later, an FIR was registered against the couple under IPC, the Child Labour Act, and the Juvenile Justice Care and Protection of Children Act. The accused husband is a Vistara ground staff engineer, and the wife is a derostered woman pilot formerly working as a junior first officer with Indigo Airlines. In August, the wife was granted bail, and now a Delhi court has granted bail to the husband as well. While granting bail, the court observed that since his arrest in July, he had been in judicial custody. After his arrest, police custody was never sought by the investigating officer, which showed that his custodial interrogation was not required. Further, since the accused was working as an aircraft maintenance engineer at Vistara Airlines, there were no chances of his fleeing. The court also remarked that investigation in the case was pending only with respect to the opinion on the medico-legal case of the victim and to record the statement of her father. Stay tuned with us for more updates on this case. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share, and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.